Article 12, Exempting Circumstances. Exempting circumstances are those grounds for exemption from punishment because there is wanting in the agent of the crime any of the conditions which make an act voluntary or negligent. The basis for exemption from punishment would be the lack of intelligence, a lack of freedom of action, lack of intent, and of course the absence of negligence on the part of the accused. The accused would have the burden of proving the existence of an exempting circumstance because these circumstances are matters of defense. Let us distinguish between justifying and exempting circumstances. In a justifying circumstance, there is neither a crime nor a criminal because there is nothing unlawful in the act and the intent of the actor. That is why there is no civil liability except in paragraph 4 of Article 11. On the other hand, in exempting circumstances, there is a crime but there is no criminal. There is civil liability except in paragraphs 4 on accident and 7 on insuperable cause. Let's go to paragraph 1, an imbecile or insane person, unless the latter has acted during a lucid interval. The rationale for this exempting circumstance is that it is useless for the law to attempt, by threatening punishment, to prevent people from committing crimes if their mental condition is such that they cannot be the least influenced by the possibility or probability of subsequent punishment. The insane person is not punishable because he is simply outside the postulate of the law of punishment. Who is an imbecile? He is one who, while advanced in age, has a mental development comparable to that of children between 2 to 7 years of age. The imbecile is deprived completely of reason, discernment, and freedom of will at the time of the commission of the crime. Imbecility must be proven to exist at the time of the commission of the crime. As early as now, let's distinguish between imbecility and insanity based on the first paragraph of this article. The imbecile is exempt in all cases from criminal liability. It is an absolute exemption for an imbecile, while the insane is not so exempted if it can be proved that he or she acted during a lucid interval, during which, of course, he is presumed to have acted with intelligence. In discussing imbecility, we might as well consider the following terminologies. An idiot is a person with the mental age of a 2-year-old. An imbecile is a person with a mental age between that of a 2-year-old and a 7-year-old. A feeble-minded is that with a mental age of a 12-year-old. He is not going to be exempt from criminal liability because he does not have the definition of an imbecile. But of course, the mitigating circumstance of weakness of the mind due to a mental illness would be appreciated in his favor. So if the accused is 18 years old, that is his chronological age, but during the trial and during his evaluation, it was diagnosed that he had the mental age of a 9-year-old. Would he be exempted from criminal liability? The answer, of course, is no. Minority is not present because he is not below 18, but then neither is imbecility because he does not have the mental age of someone between 2 and 7. Therefore, in this case, there will only be a mitigating circumstance to be appreciated on the part of the accused. Who is an insane? He is one who is completely deprived of intelligence, reason, discernment, or free will in committing the act. Section 1039 of the Revised Administrative Code defines insanity as a manifestation in language or conduct of a disease or defect of the brain, or a more or less permanently diseased or disordered condition of the mentality, functional or organic, and characterized by perversion, inhibition, or disordered function of the sensory or of the intellective faculties, or by an impaired or disordered volition. In the case of People versus Danao, a November 1992 case, it was held that insanity exists when there is complete deprivation of intelligence in committing the act. That is, the accused is deprived of reason. He acts without the least discernment because there is complete absence of the power to discern, or there is total deprivation of the freedom of the will. The court there said that mere abnormality of the mental faculties will not be enough to inculpate imputability. Now, in reality, there is really no exact definition of insanity. The mind cannot be compartmentalized into the intellect, the emotion, and the will. These are so closely interrelated. In fact, the term insanity is not anymore just confined to a place we call the mind, but it now includes altered relationships between a man and his fellow beings. Now, how is insanity manifested? Insanity is evinced by a deranged and perverted condition of the mental faculties, which is manifested in language or conduct. We consider the deranged person's general conduct and appearance, his acts and conduct consistent with his previous character and habits, as well as his improvident bargains. The vagaries of the mind can only be known by outward acts, by means of which one can read the thoughts, the motives, and emotions of a person, and through which can be determined whether the acts conform to the practice of people of sound mind. We consider the acts prior to, simultaneous with, and after the commission of the crime. Many times, however, it has been ruled that the total lack of motive to kill the victim may support insanity. Of course, considering the acts of the accused prior to or during the commission of the crime. Now, in many cases, the following acts immediately after or subsequent to the commission of the crime do not manifest insanity. Number one, remorse or surrender. I will not enumerate anymore. I will not number it anymore. Remorse, surrender, the execution by the defendant of a sworn statement, recalling the moments prior to the commission of the crime, because it's impossible for the memory to be all right before the killing, then not all right at the time of the killing, and then all right again at the time of the recollection of the events. Also, threatening the victim with death is a manifestation of insanity, especially if that threat was actually fulfilled. Killing in a fit of rage or doing crazy things when a person is angry does not mean that he or she is actually crazy. There is a vast difference between a genuinely insane person and one who has worked himself up into such a frenzy of anger that he fails to use reason or good judgment in what he does. So if the man really has a temper which he takes out on his wife whenever he's tired, and he beats her up every day, but one day he beat her up a bit much more than he did previously, he cannot say that he was angry or he lost his sanity. No. He really would be characterized as a person with anger management issues, but that would not make him an insane at the time of the commission of the crime. Now, in our jurisdiction, the law presumes sanity. A person, let's say, is seeing a psychiatrist, and then one afternoon he kills his neighbor. Just because he's seeing a psychiatrist doesn't mean he is crazy. And of course, it would not mean that he was crazy at the time of the commission of the crime, because the law still presumes the existence of sanity. Who has the burden of proving insanity? Of course, the defense, because sanity, being the normal condition of the mind, is always presumed. It is in the nature of confession and avoidance as a matter of defense. Now, the basis of our statement that the law presumes the sound condition of the mind would be Article 800 of the Civil Code, which provides that the law presumes that every person is of sound mind in the absence of proof to the contrary. Now, once we just said that sanity is what the law presumes, but once a person has been adjudged as insane, insanity is also presumed to continue. So in one case, suppose the person has been seeing a psychiatrist, and then one afternoon he kills his neighbor. During trial, upon examination by an accredited psychiatrist of the court, it was determined that he was insane at the time of the commission of the crime. The court, it is mandatory for the court to order the institutionalization of this person who has just been adjudged insane. Now, once adjudged insane, that insanity is presumed to continue. Of course, this is only a presumption as well. Now we're going to ask, how much proof is required to prove insanity? Of course, proof beyond reasonable doubt. To repeat, mere abnormality of the mental faculties is not enough, especially if the offender has not lost consciousness of his acts. At most, the loss of consciousness of one's actions at the time of the commission of the crime would be considered as a mitigating circumstance only. Not every aberration of the mind or exhibition of mental deficiency is insanity. In the case of People versus Pambid, a March 15, 2000 case, on the basis of complaint filed by the mother of a 6-year-old girl, the prosecutor's office filed an information charging accused appellant Pambid, 23-year-old adult, with 2 counts of rape. The court said that by the totality of the acts of the accused appellant, it showed that he was fully conscious of what he was doing. The bare testimony of the accused appellant's father that his son had suffered some mental illness during childhood, and that both his maternal aunt and his brother had been previously confined at the National Mental Hospital, is inadequate to prove that accused appellant himself was completely deprived of reason when he raped the 6-year-old girl. In the same case, the court even said that it was error for the trial court to appreciate the mental illness of accused appellant as a mitigating circumstance, because according to the court, the defense has failed to conclusively establish that accused appellant was suffering from schizophrenia or any mental illness that could diminish his willpower at the time immediately preceding or during the commission of the crime. Remember that when the mental illness completely deprives the offender of the consciousness of his acts, that mental illness would be an exempting circumstance. But when the mental illness does not completely deprive him of the consciousness of his acts, instead it simply diminishes the exercise of his willpower, then that mental illness will be considered as a mitigating circumstance only. Know that in proving the insanity of the accused, direct testimony is not required, nor are specific acts of derangement essential to establish insanity as a defense. Circumstantial evidence, if clear and convincing, will suffice. Of course, the evidence of insanity must refer to the time preceding the act being prosecuted or to the very moment of its execution. Now, even as we repeatedly say that the insanity of the defendant must exist at the time of the commission of the crime, it is still permissible to receive evidence of his state of mind during a reasonable period, both before and after that time. Suppose that it was proved that while the accused and the victim, who were husband and wife, suppose that it was proven that the husband always referred to his wife as his dog, and was even afraid of this creature all the time during his lifetime, because during his life or during the lifetime of the woman, because the man believed that his wife was a dog with rabies. Would that be evidence of insanity? Yes, because that would show that sometime before the commission of the crime, the frame of mind or the state of mind of the accused was no longer similar to that of people of sound mind. Now, of course, if the accused was sane at the moment that the crime was planned, but insane at the time of the commission, and of course, he will be exempt from criminal liability. To repeat, it is at the very moment of the commission of the crime, and or immediately prior to that moment. That is a point when sanity must be existent. Now, if the defendant was sane at the time of the commission of the crime but became insane at the time of the trial, he will not be acquitted. He will not be exempt from criminal liability, but of course the trial will be suspended until his mental capacity can be restored. So if a woman killed her daughter, therefore she was charged with parricide at the prison, her fellow inmates, let's say, ganged up on her and beat her up almost every day. Eventually, she became insane. During the trial, her lawyer pled insanity. To be sure, she was being beaten up as a detention prisoner. Okay, so that during the trial, trial of this same defendant, her lawyer pled insanity. Will insanity be in favor of this person who had killed her daughter? The answer, of course, is no. Even if the accused mother was insane at the time of the trial, since she was not insane at the time that she committed the crime, she cannot be in any way exempt from criminal liability. Not even a mitigating circumstance. Okay, let's now go to acts which are embraced in a plea of insanity but do not really make the accused insane at the time of the commission of the crime. In other jurisdictions, the defense of insanity must be distinguished from defense of automatism, or what we call defense of unconsciousness, but not in our courts. The defense of unconsciousness in our jurisdiction is embraced in the plea of insanity. These are what we call automatistic acts. Automatistic acts are concomitants of mental disturbance which, although affecting the elements of will and voluntariness, may or may not be sufficient to establish legal insanity. The difference really is the difference is still significant because of the factor of institutionalization. As lawyers, we want to stress that the acts of the accused constitute automatism, which would be embraced in the term insanity. We don't want to say that the accused was insane at the time of the commission of the crime. No. We want to say instead that the act of the accused is embraced in a plea of insanity. Let's talk about these automatistic acts. Somnambulism, this is the defense of unconsciousness. Sleepwalking, where the acts of the person are automatic and of which he is totally unconscious of, is embraced within the term insanity and must be, of course, clearly proven. There are what we call somnambulism experts or doctors who are experts in the field of sleep problems. In somnambulism, the act of the person is not voluntary when he does not have the intent and intelligence while doing the act. He is not conscious while doing the act. Famous cases on somnambulism would be the case of U.S. versus Odicta, a March 21, 1905 case. You have People versus Jimena, and of course People versus Taneo, a March 31, 1933 case. People versus Jimena, that would be GR number 33877. Let's discuss these cases one by one. In Odicta, the court said that it being evident that the defendant was the sole principal in the commission of the crimes of parricide, he killed his wife and daughter. There remains only the question as to whether in the case there is any circumstance which should exempt him from liability, since the reason for the commission of the horrible crimes would not appear. From the evidence adduced during the trial, it appears that the defendant was in a healthy condition prior to or at the time of the commission of the crime, that his mental condition was normal, and the legal presumption therefore was that he acted in his right mind. And all said, it was the duty of the defense to show that he was suffering from mental derangement or in a fit of insanity. Sorry, I had to drink water. The court said that such circumstance has not been shown, and therefore the defendant was considered guilty and criminally liable for the crimes of parricide. The attorney for the defense asks that his client be acquitted because at the time of the commission of the crime, his client was in a state of somnambulism akin to insanity. But such fact, as we've just said earlier, was not proven in the case. Even the somnambulism doctor said that he was not acting in a state of somnambulism at the time of the commission of the crime. What was clearly shown during the trial was that defendant was drunk at the time he killed the members of his family and did not know what he was doing. And he actually admitted killing them and said that he was drunk at the time that he killed them. And the court said that there was no legal reason why the statement of the defendant should not be taken into consideration. Especially because the other witnesses who saw him several hours after the crime had been committed. Notwithstanding the fact that the witnesses said that he was not drunk at the time of the commission of the crime, But since it was the appellant himself who kept saying that he was drunk at the time of the commission of the crime, the court said, then why shouldn't we take the statement against you? Especially because it seemed really true, because he had no other reason to kill the members of his family. However, because of that intoxication, which was proved as non-habitual and non-intentional, then that was taken to mitigate his criminal liability. In the case of People versus Taneo, somnambulism was raised as a defense, and in this case, the defendant was acquitted, but he was ordered by the court to be confined in an asylum. It appeared from the evidence brought out during trial that the day before the commission of the crime, the defendant had a quarrel over a glass of tuba with two persons who invited him to come down to fight. And when the defendant was about to go down, he was stopped by his own wife and his mother. Now, on the day of the commission of the crime, that afternoon, it was noted that the defendant was sad, he was weak, and he was restless. He even had a stomachache, which made it necessary for him to go to bed early. And then he fell asleep. The defendant stated that when he fell asleep, he dreamt that one of the two people whom he had a fight with earlier that day was trying to stab him with a bolo, by reason of which he got up, and as it seemed to him that his enemies were inviting him to come down, he armed himself with a bolo and left the room. At the door, he met his wife, who seemed to say to him that she was wounded. That was everything, or that was all that the accused could remember. His wife saying, you wounded me. And then he realized in a quick moment that his wife was really wounded, and in desperation he wounded himself as well. This was still part of his dream, he thought, okay? And then as his enemies seemed to multiply around him, he attacked everybody that came his way. The court said that the defendant not only did not have any trouble with his wife, but that he was a very loving husband. He also did not have any dispute with the family members of his wife. So the court concluded that the defendant acted while in a dream, and that his acts were not voluntary in the sense of entailing criminal liability. Then you have the case of People versus Jimena. Again, the defense of the accused was that he committed the crime during a state of somnambulism, but the court did not believe him. It appears from the evidence that on the morning that the crime was committed, the defendant helped his father-in-law in cleaning bamboo. Afterwards, he went home, and upon arriving home, he found his wife and a child, 2 weeks of age, sleeping together on the floor. Shortly afterwards, his father-in-law, according to testimony of the father-in-law, heard his daughter, the defendant's wife, crying for help. He went to the defendant's house, which was very close to his own, and found that the defendant was attacking his daughter with a bolo. And of course, they succeeded with the help of other individuals. The father-in-law of the defendant succeeded in disarming the defendant until the authorities, of course, arrived. So there was really a motive for killing his wife in that case, which was jealousy. Okay, another, so much for the cases in somnambulism. Another automatistic act would be hypnotism. Hypnotism is artificial somnambulism. As of now, there is no exact jurisprudence on hypnotism, so it is not an exempting circumstance. We also have kleptomania, or the abnormal persistent impulse or tendency to steal. The case must be investigated by a competent psychiatrist to determine whether the impulse to steal is irresistible or not. If the unlawful act is due to the mental defect of the accused, producing an irresistible impulse to steal, as when the accused has been deprived of the power of his will, then, well, maybe this disease may be covered by the term insanity. On the other hand, if the defect only diminishes the exercise of his mental power, but does not deprive him of the consciousness of his act, then kleptomania, even if this be the result of his mental disease, would only be a mitigating circumstance. For instance, if the accused picked some valuable items in a store and put all of them in her bag. Once she got out of the store, she dropped all the expensive items. Will insanity be taken in her favor? Well, that would show that she regretted stealing them. So that would show that he knew that he had stolen them. So how about selective kleptomania? In one case, if the accused steals in expensive stores, but when you take him to the not expensive stores, for example, you take him to Divisoria, Baclaran, he doesn't steal. So that is selective kleptomania. That could not be the same as insanity or a disease which deprives him of the consciousness of his act. Another automatistic act is the commission of a crime while suffering from malignant cerebral malaria. This disease affects the level of consciousness, causing paralysis and convulsions. As a general rule, there could be no criminal liability because once it affects the nervous system, it would cause such complication as acute melancholia, as stated in the books, and insanity at times, unless it can be proved that the malaria was not yet at its most severe case so as to cause such loss of intelligence at the time of the commission of the crime. In an old case, People versus Lacena, the wife killed her husband while she was in a state of malaria. She was acquitted but institutionalized, presumably because her case was considered as automatistic acts embraced in a plea of insanity. How about schizophrenia, or formerly known as dementia praecox? It is a mental disorder which is characterized by the inability to distinguish fantasy from reality. The factors to consider are the mental disease and a critical relationship between that disease and the criminal act, and of course, proof beyond reasonable doubt that the defendant understood his actions as a violation of the law, but that he did not have the capacity or competence to choose between doing it and refraining from doing it. As a general rule, again, it is exempting because the actor is prone to homicidal attacks. However, if it can be proved that the actor was not insane at the time of the commission of the crime, schizophrenia will at most be a mitigating circumstance. Know that in the present day and age, schizophrenic persons can even be gainfully employed. So that in the absence of proof that at the time of the commission of the crime there was complete loss of consciousness of one's actions, then even schizophrenia cannot be an exempting circumstance. We also have feeble-mindedness, or what we call slow-mindedness. This is not imbecility. This is also not insanity. But in several cases a number of cases decided by the late Justice Relova, uh, feeble-mindedness was held as an exempting circumstance. In those cases, many years ago, decided by Justice Relova. You also have epilepsy. Epilepsy is a chronic nervous disorder characterized by fits occurring at intervals, attended by convulsive motions of the muscles and loss of consciousness. To be exempting, accused must show that he was under the influence of an epileptic fit when he committed the offense. That is the ruling of the court in People versus Bancao and Aguilar, an old case. Pedophilia, a sexual disorder wherein the subject has strong, recurrent, and uncontrollable sexual and physical fantasies about children, which he tries to fulfill, especially when there are no people around. It is not equivalent to insanity at all. And of course, amnesia, failure to remember an event, in and itself is of no defense unless it can be proved that the accused did not know the nature and quality of his action and that it was wrong. But the general rule, of course, is that failure to remember is not proof of the mental condition of the accused when the crime was committed. Now, before we leave paragraph 1, know the two tests of insanity: the test of cognition and the test of volition. In the test of cognition, the accused has complete absence of intelligence. In the test of volition, what the accused lacks is freedom of the will. There is an absence of freedom of the will. Our courts follow the cognitive test. We consider the lack of freedom of the will only as a mitigating circumstance because a person's volition extends only to that which is deemed desirable by him based on his intelligence, whether that intelligence is healthy or diseased. So in many cases, the accused would pass the volition test but fail the cognition test, in that the court or the evaluation by a competent psychiatrist would yield that he had no freedom of the will, no complete freedom of the will, but he had intelligence, in which case he would not be exempt from criminal liability. For example, let's say that the accused, there is a serial killer on the loose, and because of this, accused would bring with him a pen knife, everywhere he went. One night he came home from his work. Let's make him a call center agent, and as he walked from his place of work to his house, which usually took about an hour, for half that time, let's say 30 minutes or even more, someone was following him. So he thought this could be the serial killer on the loose. He turns around, this person was staring at him, and he stabs this person. He says that he was completely paranoid. Would that be an exempting circumstance? Paranoia does not mean that the paranoid individual was deprived of intelligence at the time of the commission of the crime. At most, this would be an evidence of absence of freedom of the will. He would pass the volition test, but he would not pass the test of cognition. Let's now go to paragraph 2 and paragraph 3 as well of Article 12. These paragraphs refer to minorities, so it would be good to discuss them or whatever remains of them together. Paragraph 2, a person under 9 years of age. This has been modified by RA 9344 or the Juvenile Justice and Welfare Act because the age for exemption from criminal liability has been raised from 9 to 15. So in that sense, paragraph 2 has been modified by RA 9344. Now, paragraph 3 has not only been modified, it has been repealed by RA 9344. Paragraph 3 provides that a person over 9 but under 15 would not be absolutely exempt from criminal liability. This has been impliedly repealed by RA 9344, as I've said, because if the person is over 15, in paragraph 3, a person over 9 but under 15 would be exempt from criminal liability unless he has acted with discernment. As I've said, this paragraph has been impliedly repealed by RA 9344 because the exemption is no longer qualified for a child over 9 but under 15. He would now be absolutely exempt from criminal liability as long as he is 15 years old. Doesn't matter about discernment, being under 15, being 15 and under would be an absolutely exempting circumstance under RA 9344. Now, as we've said earlier, in imbecility, what is important is the mental age of the accused. On the other hand, in minority, the important consideration is the chronological age of the accused. The basis of this exempting circumstance in RA 9344 is complete absence of intelligence. It is important, however, to determine the age of the child at the time of the commission of the offense. But of course, in case of doubt, minority must be resolved in favor of the child. Now, let us discuss RA 9344, the Juvenile Justice and Welfare Act of 2006. This became effective on March 20, 2006. RA 9344 is a system dealing with children at risk and children in conflict with the law, which provides for child-appropriate proceedings, including programs and services for the prevention, diversion, rehabilitation, reintegration, and aftercare to ensure the normal growth and development of the child. Under Section 6 of this law, to repeat, the age of absolute irresponsibility was raised from 9 years old under the revised penal code to 15 years old. A child 15 years of age or under at the time of the commission of the offense shall be exempt from criminal liability. If the child is above 15 but acting without discernment, he is still exempt from criminal liability. In both cases, however, the child shall be subject to an intervention program as provided under Section 20 of the law. On the other hand, if the child is above 15 but below 18 and acting with discernment, he will undergo a diversion program under the law. Now, Proving the age of the child is found in Section 7 of RA 9344. You present the birth certificate of the child, other documents or authentic records such as baptismal certificate, school records, or any pertinent document showing the date of birth of a child if that birth certificate is not available, or if the birth certificate or the other documents mentioned are also not available, then you can prove the child's age by the testimony of the child or a member of his family or of other persons before the family court, and the family court must render the decision within 24 hours from receipt of the appropriate pleadings of all the parties relative to the age of the child. Now let's define a child. Under RA 9344, he or she is anybody below 18. There are, however, other statutory definitions of a child found in other laws. Under RA Under RA 7610, a child is, let's see, remember RA 7610. A child is any person below 18 years of age or over, but is unable to fully take care of himself or herself, or protect himself or herself from abuse, neglect, cruelty, or exploitation or discrimination because of a physical or mental disability or condition. That is a definition of a child under RA 7610, the child abuse law. On the other hand, under RA 9755, the Child Pornography Act of 2009, a child refers to any person below 18, very much like the definition of a child under RA 7610, but it also includes a person regardless of age who is presented, depicted, or portrayed as a child, or a computer-generated digitally or manually crafted images or graphics of a person who is represented or is made to appear to be a child as defined in the law. Now, under RA 9344, as we've just said, a child is anyone below 18, and he may either be a child at risk or a child in conflict with the law. A child at risk refers to a child who is vulnerable to and at the risk of committing criminal offenses because of personal, family, and social circumstances, such as but not limited to the following: being abused by any person through sexual, physical, psychological, mental, economic, or any other means, and the parents or guardian refused or unwilling or unable to provide protection for the child. Being exploited, including sexually or economically. Being abandoned or neglected, and after diligent search and inquiry, the parent or guardian cannot be found. Coming from a dysfunctional or broken family or without a parent. Being out of school. Being a street child. Being a member of a gang. Living in a community with a high level of criminality or drug abuse, and living in situations of armed conflict. Now, a child in conflict with the law under RA 9344 refers to a child who is alleged as, accused of, or adjudged as having committed an offense under Philippine laws. Now, RA 10630 was enacted, amending RA 9344, and provided another category of a child, which would be a neglected child. This was passed in July 2012. A neglected child under RA 10630 is defined in Section 20A of the child. A child who is above 12 years of age up to 15 years of age and who commits parricide, murder, infanticide, kidnapping, and serious illegal detention where the victim is killed or raped, robbery with homicide or rape, destructive arson, rape, or carnapping where the driver or occupant is killed or raped, or offenses under the Republic Act 9165 or the Comprehensive Dangerous Drugs Act of 2002, punishable by more than 12 years of imprisonment, shall be deemed a neglected child under PD 603 as amended and shall be mandatorily placed in a special facility within the youth care faculty or Bahay Pag-asa. So, under RA 10630, a neglected child as defined in the Child and Youth Welfare Code is one who has committed serious crimes but who is exempt from criminal responsibility because he or she is above 12 years old up to 15 years old at the time of the commission of the crime. We can see that RA 9344 has altered the periods of criminal responsibility in the RPC as follows. The age of absolute irresponsibility is now 15 years old and below. The age of conditional responsibility is now 15 years and 1 day to less than 18, depending on whether the minor acted with discernment. The age of full responsibility is 18 years old or over up to 70. And the age of mitigated responsibility is that of 15 years old or over but less than 18, acting with discernment, and of course being over 70 years old. Under RA 9344, aside from exemption from punishment, the child under 18 is also exempt from other offenses. These would be found in sections 57 to 59 of RA 9344. Section 57, a child would be exempt from criminal liability for status offenses. Any conduct not considered an offense or not penalized if committed by an adult shall not be considered an offense and shall not be penalized if committed by a child. Section 58, persons below 18 years of age shall be exempt from prosecution for the crimes of vagrancy and prostitution under Section 202 of the Revised Penal Code, Article 202. Know, of course, that the vagrancy, the crime of vagrancy has been repealed. The child below 18 shall also be exempt from punishment for mendicancy under PD 1563 and for the sniffing of rugby under PD 1619. That's why you can always see a child sniffing rugby on the street, very much unafraid that a policeman would catch him. Notwithstanding their exemption from these offenses, they shall still undergo appropriate counseling and treatment. Of course, no death penalty shall ever be imposed upon children, especially children in conflict with the law. That is in Section 59 of RA 9344. The law presumes minority. The child in conflict with the law shall enjoy the presumption of minority and shall enjoy the rights and privileges of a child in conflict with the law until proven to be 18 or older at the time of the commission of the offense. Now, any person alleging the age of the child in conflict of the law or contradicting that age has the burden of proving the age of the child. If the age of the child is contested prior to the filing of the information in court, a case for the determination of the child's age under summary proceeding will be filed. And of course, the birth certificate will be admissible in favor of the child, even if the same is not offered at the trial. Okay, we have said earlier that a child above 15 and below 18 acting without discernment is still exempt from punishment, but he will have to undergo diversion programs. Now, what is discernment? It is the mental capacity to understand the difference between right and wrong, which attitude shall be determined by taking into consideration all the facts and circumstances afforded by the records in each case, the very appearance, the attitude, the comportment and behavior of the minor, not only before and during the commission of the offense, but also after and even during the trial of this minor. Now, how do we prove discernment? By the manner of committing the crime, and of course, as we've said, the conduct of the offender. Note that the lack of discernment, which is essential to exempt from criminal responsibility, must be alleged in the complaint or information. An allegation of intent to kill, however, in the information is sufficient evidence of discernment. Let's give examples. Suppose that the accused, 16 years old, tied the hands of the victim to a tree and punched the victim several times until the latter died. The manner of committing the crime would show that the minor had discernment at the time of the commission of the crime. Now, suppose the minor chained her victim's body and laughed after realizing that this victim is already dead. He sets fire to the body of the victim, the corpse. His actions after the commission of the crime also show discernment. Now, let's talk about diversion. Okay, to repeat, when the child is 15 and below at the time of the commission of the crime, he is exempt from punishment. If he is above 15 but below 18 and acting without discernment, he is still exempt from punishment. But in both cases, the child will undergo an intervention program. Now, suppose a child is above 15, below 18, but this time acting with discernment. In other words, you could say that he understood the consequences of his actions and that he understood the morality attached to his action. If he acted with discernment in the commission of the crime, he will undergo what we call a diversion program. Diversion refers to an alternative child-appropriate process of determining the responsibility and treatment of a child in conflict with the law on the basis of his or her social, cultural, economic, psychological, or educational background without resorting to formal court proceedings. In other words, a diversion program refers to the program that the child in conflict with the law is required to undergo after he or she is found responsible for an offense without resorting to formal court proceedings. Now, how this diversion program is provided or who provides the diversion program would depend on the imposable penalty for the crime committed by the minor and whether or not there is a victim. In other words, whether or not there is a private individual who suffers because of the action or the crime committed by the minor. There are 3 rules to remember: where the imposable penalty for the crime committed is not more than 6 years of imprisonment, the law enforcement officer or punong barangay will provide the diversion program. An example of a crime where the penalty is not more than 6 years of imprisonment would be less serious physical injuries. Okay, now, second rule you have to remember: in victimless crimes where the imposable penalty is not more than 6 years of imprisonment, the local social welfare and the development officer will provide their rehabilitation programs. An example of a victimless crime would be alarm and scandal. There is no victim there. It's really the tranquility of the public that is affected in the crime of alarm and scandal under Article 155. The penalty for that is arresto menor. In other words, it's not more than 6 years of imprisonment. Okay. The last rule to remember: where the imposable penalty for the crime committed exceeds 6 years imprisonment, diversion measures may be resorted to only by the court. Can we think of crimes where the penalty is more than 6 years of imprisonment? An example of a crime where the imposable penalty exceeds 6 years of imprisonment would be, let's say, in Title 4, Crimes Against Public Interest. Anybody who uses the forged signature of the president under Article 162 would suffer the penalty of prisión mayor. That is an example of, and if the offender is a child, the diversion measure would be provided only by the court. Now, know that the period of prescription of the offense, because as we've said, there will be no formal proceedings at this time during the diversion program, that is, the period of prescription of the offense shall be suspended during the effectivity of the diversion programs, but of course not exceeding a period of 2 years. Now, if the offense does not fall under the first 2 rules that we have mentioned, under Section 23, paragraphs A and B, in other words, if the case is not where the crime committed is not more than 6 years of imprisonment, or where it is not more than 6 years and it is a victimless crime, in those cases that do not fall under the ones we have just mentioned, in other words, the imposable penalty exceeds 6 years, or in any case where the child or his or her parents or guardian does not consent to a diversion, the punong barangay handling the case shall, within 3 days from the termination of the absence of jurisdiction over the case or the termination of the diversion proceedings, as the case may be, the punong barangay will forward the records of the case of the child to the law enforcement officer, the prosecutor, or the appropriate court, as the case may be. And upon issuance of the corresponding document certifying to the fact that no agreement has been reached by the parties, the case shall now be filed according to the regular process. In other words, there will be a preliminary investigation, and then there will be a trial, and so forth. Okay. In other words, when there is no diversion program, the law enforcement officer handling the case of the child under custody would now tell the prosecutor or judge concerned that there have to be an inquest or preliminary investigation to determine whether or not the child should remain under custody and correspondingly charged in court. That is in section 28. The Women and the Child Protection Desk of the PNP or other law enforcement officer handling the case of the child under custody shall forward the case to the prosecutor or judge concerned for the conduct of inquest and or preliminary investigation. Now, there shall be a specially trained prosecutor to conduct the inquest, the preliminary investigation, and prosecution of cases involving a child in conflict with the law. That's under Section 32. And under Section 33, upon determination of probable cause by the prosecutor, the information against the child in conflict with the law shall now be filed with the family court within 45 days from the start of the preliminary investigation. Now, under Section 35, where the child is detained, the court shall order the release of the child and recognizance to his parents or other suitable person, or the release of the child in conflict with the law on bail, or the transfer of the minor to a youth detention home or a youth rehabilitation center. The court shall not order the detention of a child in jail pending the trial or hearing of the child's case. In all cases, detention pending trial may still be replaced by alternative measures such as close supervision, intensive care, or placement with a family or in an educational setting or home. The institutionalization or detention of the child pending trial shall only be a measure of last resort and for the shortest possible period of time. And the detention is never in court. I'm never in a jail, by the way. To repeat, it's never going to be in jail. It will be in a youth detention home. If there's no youth detention home, the child in conflict with the law may be committed to the care of the DSWD or a local rehabilitation center. Now, as we've said, trial is now going on. How about if the child is convicted after trial? Under PD 603, under RA 9344, even if the child is convicted, he will be entitled to the automatic suspension of his sentence. Now, under PD 603, the following minors will not be entitled to automatic suspended sentence. Number 1, the minor who has once enjoyed a suspended sentence. Number 2, the minor who is convicted for an offense punishable by death or life imprisonment. So if he has killed somebody, murdered somebody, under PD 603, the minor is not entitled to automatic suspended sentence. Under PD 603, a minor who is convicted by a military tribunal is also not entitled to automatic suspended sentence. Now, the disqualification for suspension of sentence is contained in Section 38 of RA 9344. it provides, once the child who is under 18 years of age at the time of the commission of the offense is found guilty of the offense charged, the court shall determine and ascertain any civil liability which may have resulted from the offense committed. However, instead of pronouncing the judgment of conviction, the court shall place the child in conflict with the law under suspended sentence without need of application, provided that suspension of sentence shall still be applied even if the juvenile is already 18 years old or more at the time of the pronouncement of his guilt. What Article 40 tells us is that the suspension of sentence of a minor is automatic. He does not need to apply for suspended sentence. Know also that the disqualifications for automatic suspended sentence under PD 603, the first two, referring to a minor who has once enjoyed suspended sentence, or a minor who is convicted for an offense punishable by death or life imprisonment, those two are retained in RA 9344. The minor in those cases also do not enjoy automatic suspension of sentence. The addition in RA 9344, however, is that if the child in conflict with the law has reached 18 years old while under suspended sentence, the court shall determine whether to discharge him or to execute his sentence or to extend the suspension of sentence for a certain period of time until the child reaches the maximum age of 21 years old. That is found in Section 40 of RA 9344. In other words, Section 40 of RA 9344 is both good and bad for the child. It's good because there's another opportunity for the child to avoid imprisonment. If the court decides to extend the suspension of sentence until the child reaches 21, then he avoids imprisonment in the meantime. Section 40 is bad or not very good because the suspension will not be applicable, not even retroactively, if the child has reached 21 at the time of the promulgation of the judgment. Because once the child reaches 21, the court will decide whether or not to execute the sentence. Okay, now let's go to the good part. Let's continue with that. As the child's sentence is suspended, the child actually has another opportunity to avoid incarceration, which is when the diversion or the extension of such diversion proves successful insofar as the child is concerned. Section 39 of RA 9344 provides that upon recommendation of the social worker who has custody of the child, the court shall dismiss the case against the child whose sentence has been suspended and against whom disposition measures have been issued, and shall order the final discharge of the child if it thinks or if it finds that the objective of disposition measures have been fulfilled. The discharge of the child in conflict with the law shall not affect the civil liability resulting from the commission of the offense, which shall, of course, be enforced in accordance with the law. So you see, if the diversion becomes successful or he still changes during the extension of the diversion, then it is as if he was exempted right from the beginning. there will be an order of release or discharge of the child in conflict with the law. Now, how about if the diversion is not successful? If the diversion is not successful, in spite of the extension, as we have mentioned in section 40, the child in conflict with the law shall be brought before the court for the execution of judgment. But of course, the child in conflict with the law shall be credited in the service of his or her sentence with the full time spent in actual confinement and detention under this act that is found in section 41 of RA 9344. Now, does this mean eventual imprisonment for the child? Not really. The child can still avoid imprisonment. This is the last opportunity to give him a chance to be rehabilitated or integrated into society. And what are these chances? You have section 42 and section 51 of RA 9344. The court may, after it shall have convicted and sentenced a child in conflict with the law, and upon application at any time, place the child on probation in lieu of service of the child's sentence, taking into account the best interests of the child. And so for this purpose, section 4 of PD 968, otherwise known as the probation law of 1976, is amended accordingly. Remember what we took up in probation. Probation is an application for probation is a waiver of the right to appeal. And similarly, an appeal is a waiver of the right to apply for probation. But this is not applied to a child. You also have section 51. A child in conflict with the law may, after conviction and upon order of the court, be made to serve his or her sentence in lieu of confinement in a regular penal institution, in an agricultural camp, and other training facilities that may be established, maintained, supervised, and controlled by the Bucor in accordance with the DSWD. And finally, remember that under section 43 of RA 9344, all records and proceedings involving the child in conflict with the law from the initial contact until final disposition of the case shall be considered as privileged and confidential. A person who has been in conflict with the law as a child shall not be held under any provision of law to be guilty of perjury or of concealment or misrepresentation by reason of his or her failure to acknowledge the case or recite any fact related thereto in response to any inquiry made to him or her for any purpose. That is in section 43 of RA 9344. Those are the important provisions in RA 9344 relative to minority as an exempting circumstance. Let us now go to paragraph 4. Any person who, while performing a lawful act with due care, causes an injury by mere accident without fault or intention of causing it. The basis of this circumstance is lack of criminal intent. It is an accidental result flowing out of a legal act and without negligence. Of course, the burden of proof lies with the accused, which he must prove the accident by clear and convincing evidence. But of course, the burden of proving the guilt of the accused beyond reasonable doubt in any case will always rest with the prosecution. Note that this is the only paragraph in Article 12 where there is no civil liability, aside from, of course, paragraph 7 on insuperable cause. Let us define an accident. An accident, as defined in the case of Harrow Marketing Corporation versus CA, is a fortuitous circumstance, event, or happening. It's an event happening without human agency, or if happening wholly or partly through human agency, an event which under excuse me, pardon me please, an event which under the circumstances is unusual or unexpected by the person to whom it happens. Please excuse me there. Negligence, on the other hand, is a failure to observe for the protection or interest of another person that degree of care, precaution, and vigilance which the circumstances justly demand, without which such other person suffers injury. Accident and negligence can never exist with each other. They are intrinsically contradictory. In an accident, the circumstances are unforeseeable. If they are foreseeable, it will be a case of negligence. The elements of an accident are: a person is performing a lawful act with due care, it causes an injury to another by mere accident and without fault or intention of causing it. Now, if what is missing is the second requisite of due care and the fourth requisite of absence of fault, the first part of the fourth requisite, then if there is no due care and there is fault, then in the absence of those two requisites, we would have an incomplete accident. What we will have instead is a felony committed through negligence. The act, in other words, will be treated as a culpable felony and will be punished with the same penalty as that provided in Article 365, Paragraph 1 for quasi-offenses. Let me look at Article 365 here. Any person who by reckless imprudence shall commit an act which, had it been intentional, would constitute a great felony shall suffer the penalty of arresto mayor in maximum to prisión correctional medium. If it would have constituted a less grave felony, the penalty of arresto mayor in its minimum and medium. If it would have constituted a light felony, the penalty of arresto minor in its maximum period shall be imposed. So that the same, it would be the same in the exempting circumstance of an accident. If there is fault or negligence, you will have a culpable felony, and the penalty is found in the provision we've just read. Know that if you go to Article 67, the penalty provided in Article 365 is the same as the penalty provided in Article 67. So when you think about it, Article 67 really is a dead law. Why? Because it refers to the penalty for incomplete accident. But we've just said that if what is missing is lack of fault or if there's negligence, it will be treated as a culpable felony, and the penalty is in Article 365, Paragraph 1. Now, if what is missing is the first requisite and the second part of the last requisite, in other words, the offender is not performing a lawful act and he has intention of causing the injury, then we will have an intentional felony, and the penalty will be that found in the felony actually produced. That's why we say that Article 67 is a dead law. Let's give examples. Suppose that X and Y, both policemen, were having a party in a karaoke bar. They both want to sing. They both wanted to sing so badly and they couldn't wait for their turn. X drew a gun, but Y successfully grabbed it from X. The gun, however, fired and shot not only X, but also the waiter nearby. What is the liability of Y, the other policeman who was able to grab the gun from X? Y will not have any criminal liability. The third and fourth elements are present. With respect to the shooting of the waiter, Y could not have been expected to look around him while struggling for the weapon with X. That would be a clear case of accident. With respect to the shooting of X, Y would be a legitimate defense of himself. Now, suppose that it was X who shot Y and the waiter while he was fighting for the gun that he had drawn with Y. X will be liable for the killing of Y and the waiter because when he drew the gun, he was not in the performance of the lawful act. The first requisite of an accident is already missing. Suppose that while X drew his gun, because let's say he was fighting with Y, let's say as he drew his gun, it fired and killed Y and the waiter. Just in the act of drawing it, the gun already fired. The act of drawing a gun in the course of a quarrel is already unlawful. It is the crime of light threat. Hence, similarly, X would not be performing a lawful act. Examples of negligence in People versus Nokum, the accused willfully discharged a firearm without taking the necessary precaution, and this was happening in a thickly populated place. His purpose was good. He wanted to stop two men from fighting, but in discharging his firearm, he knew that it was a densely populated place. So using a revolver to stop a fight would be negligence. It would be adjudged differently from using the same revolver to prevent or repel an attack against oneself. Let's go to paragraph 5. Any person who acts under the compulsion of an irresistible force. The rationale for this is that a man acts not only without will but against his will. No law can oblige a man to abandon his own preservation. If the condition were such that if he does not do it, he will not die, but if he does, he will die later, he would certainly choose the latter option. The basis of this circumstance is a complete absence of freedom, which is an element of voluntariness. It's true that an eminently virtuous man will prefer death to crime, but the laws do not address our individual virtues. In fact, if all men were virtuous, we probably would be in need of penal laws. Let's discuss the elements of paragraph 5. Number 1, the compulsion is by means of physical force. Number 2, the physical force must be irresistible. And number 3, the physical force must come from a third person. Let's define an irresistible force. It is that kind of force which produces such an effect upon an individual that in spite of all resistance, it reduces him to a mere instrument and as such is incapable of committing a crime. It must be that such, in spite of the resistance of the person upon whom the irresistible force operates, it compels his members to act and his mind to obey. And the court said that such a force can never consist in anything that springs primarily from the man himself. It must be force that acts upon him from the outside and by a third person. In determining whether the force is irresistible, facts must be weighed together with the actor's conduct in succumbing to the pressure, since men of reasonable firmness have different breaking points depending on the stakes that are involved. Even homicide may be the product of coercion that is truly irresistible. The danger to a loved one may have a reasonable impact on a man of reasonable firmness than danger to himself. And also, long and lasting pressure may break down resistance more effectively than a threat of immediate destruction. Let's give an example of irresistible force. Suppose that X keeps slapping Y and tells Y, I'm not going to stop slapping you if you don't, let's say, kill that person beside you. And because of the slapping that he cannot tolerate anymore, Y kills the person beside him. Is that an irresistible force? What is at stake here? At stake here is the nonstop slapping of the accused. And so he would not want to be slapped anymore, so he decided to kill the person beside him. That would not be irresistible force. As we've said, the rationale for this is that no man would abandon his own preservation. But if his preservation is not at risk, or a danger of, he's not in danger of dying, he cannot say that he acted under the compulsion of an irresistible force. Even if physical force was being employed by X upon Y at that time. Let's go to paragraph 6. Any person who acts under the impulse of an uncontrollable fear of an equal or greater injury. The requisites are the existence of an uncontrollable fear. Number 2, that the fear must be real and imminent. And number 3, the fear of an injury is greater than that, or at least equal to that committed. The basis is a complete absence of freedom. The applicable legal maxim is actus me invicto factus, non est meus actus, or an act done by me against my will is not my act. The elements are that the threat which causes the fear is of an evil greater than or at least equal to that which the accused is required to commit, and that it promises of an evil of such gravity and imminence that the ordinary man would have succumbed to it. Know that the nature of duress as a valid defense should be based on real, imminent, or reasonable fear for one's life or limb. Speculative, fanciful, and remote fear is not uncontrollable fear. Duress is unavailing where the accused had every opportunity to escape if he wanted to, or resist any possible aggression because, let's say, he was also armed. Like a bare denial, this exempting circumstance is self-serving and is a negative device which by judicial experience shows that it is conveniently conjectured by felons to justify their participation in a crime. Let's give examples. Suppose that X tells Y, if you don't kill Z, I am going to kill you tomorrow. Whereupon Y looks for Z and shoots Z. Did X kill Y because of uncontrollable fear? The answer is no. A threat of future injury is not enough. The compulsion must be of such a character as to leave no opportunity for the accused to escape or an opportunity for self-defense in equal combat. The force must be irresistible so as to reduce the actor to a mere instrument who acts not only without will but also against his will. In this case, while defendant may have been threatened with violence or inflicted upon with serious physical injuries at some prior time in the future, or at some prior time, the threat came at some prior time, if he was not under immediate personal restraint at the time of the actual commission of the offense, he would not be exempt based on uncontrollable fear or not even irresistible force. Suppose that X threatens Y, I will burn your house if you don't kill Z, or if you don't, let's say it was the Japanese wartime, or if you don't swear fidelity to the imperial army. And so the accused swore to side with the imperial army of Japan, afraid that his house would burn. Or he killed Z, afraid that X would burn his house if he killed Z. That is not acting because of uncontrollable fear. The apprehension of loss of property or of slight or remote personal injury is really not uncontrollable fear. In the case of People versus Fernando, the court said that fear alone without moral compulsion is not uncontrollable fear. In that case, the mere fear of the hook movement to disobey or refuse to carry out the orders of the organization in the absence of proof of actual physical or moral compulsion to do the act is not sufficient to exempt the accused from criminal liability. Also, in one case, People versus Parulan, the accused, who had several opportunities to leave the gang who had kidnapped the victim, cannot be exempted under this article. The court also said that the threat must be serious. In the case of People versus Moreno, the threat was simply, you have to comply with the order, otherwise you will have to come with us. There was no threat that his life would be extinct if he doesn't comply with the order. The threat was simply that the words were simply that you have to comply with the order or you will have to come with us. And the court said that is not a threat of a serious character. The court said that in treason, nothing will excuse the act of joining an enemy except fear of imminent death. Otherwise, traitors in the enemy country would be shielded from any requirement of resistance. In paragraph 6, the uncontrollable fear must be continuous throughout the time when the act was being committed. Let's say that X and Y were maids who were being maltreated by their lady employer. One day they conspired to kill her. And then they told the driver who arrived just at the time that they were killing the employer, they told the driver to tie her hands or else they would also kill him. And so the driver tied the hands of the employer. The driver was charged as an accomplice. Let's say that the driver here, of course, was male and he was really a muscular man compared to the maids who were very thin, fragile. Can driver invoke paragraph 6? The answer is no. You consider his size or the fact that he had opportunity to defend himself against their threat. In such a case, he could not have acted under the impulse of an uncontrollable fear. In the case of People versus Magpantay, the court said that grave fear is not uncontrollable fear. In that case, the offender was awakened by a shot and fearing that it was another raid by armed men. Magpantay fired at a walking figure which turned out to be an innocent man on the way to go somewhere. Magpantay was convicted. The court said that grave fear, paranoia, which we now call paranoia, is not uncontrollable fear. Remember that in paragraph 5, the compulsion there refers to force or violence, but the compulsion in paragraph 6 is by means of intimidation or threat. Let us go to paragraph 7, the last paragraph. Any person who fails to perform an act required by law when prevented by some lawful or insuperable cause. This exempting circumstance clearly applies to felonies by omission, and again, just like paragraph 4 on accident, there is also no civil liability here. The elements are that the act is required by law to be done, the person who fails to perform such an act, and his failure to perform the act was due to some lawful or insuperable cause. The basis is lack of criminal intent, which is a condition of voluntariness in intentional felonies. Generally, one would not commit a crime unless some feasible and lawful alternative was available to him. In this case, the non-performance cannot be made a crime where the performance is impossible or would violate a law. An example of this would be a priest who refuses to report a conspiracy to commit treason to the public officers designated in the law on misprision of treason will not be criminally liable under Article 116. Now, related to exempting circumstances are absolutory causes. Absolutory causes exempt the actor from criminal liability, but these causes are not found in Article 12. They are those where the act committed is a crime, but for reasons of public policy and sentiment, there is no penalty imposed. Example of absolutory causes, you have Article 6 on spontaneous desistance of the person who has commenced the commission of a felony before he could perform all acts of execution. The desistance cancels criminal intent. And as we've said, in the commission of the crime, you need both criminal intent and criminal act, the mens rea and the actus reus. The desistance of the offender, the spontaneous desistance in Article 6 with respect to attempted stage of the felony, the spontaneous desistance is an absolutory cause. Article 20, accessories exempt from criminal liability. That's also an absolutory cause. Article 124, the last paragraph, that provision on the commission of a crime or violent insanity or any other ailment requiring compulsory confinement of the patient in hospital shall be considered as legal grounds for the detention of any person. The person detained cannot file a complaint for arbitrary detention against the public officer, the police officer who detained him or in a hospital because he was becoming violently insane. Of course, Article 247, paragraphs 1 and 2 refer to death or serious physical injuries inflicted under exceptional circumstances. This is also an absolutory cause. Article 280, paragraph 3, the provisions on trespass to dwelling shall not be applicable to any person who shall enter another's dwelling for the purpose of preventing some harm to himself, the occupants of the dwelling, nor shall it be applicable to any person who shall enter a dwelling for the purpose of rendering some service to humanity or justice, nor to anyone who shall enter cafes, taverns, inns, and public houses while the same are open. The person who renders some service will not be liable for the crime of trespass to dwelling. You also have Article 332, persons exempt from criminal liability for certain crimes against property. And you have Article 344, in the case of seduction, abduction, acts of lasciviousness, and rape, where there is marriage between the offender and the offended party, that marriage would be an absolutory cause. Now, let's discuss instigation and entrapment. In instigation, the police officer or the public officer or a private detective induces an innocent person to commit a crime and would arrest this person upon or after the commission of the crime by the latter. It is an absolutory cause. The accused is induced or enticed to commit the crime. In an instigation, the law enforcement officer conceives the crime and then he suggests this to the accused, and the accused adopts the idea and carries it into execution. The public authorities here have taken active steps to lead the accused into the commission of the crime. That is why it is an absolutory cause. The court said that human nature is frail enough at its best and requires no encouragement in wrongdoing. If we cannot assist another and prevent him from committing a crime, we should at least abstain from any active efforts in the way of leading him into temptation. That's why in instigation, the accused has to be acquitted. Instigation consists of two elements: the acts of persuasion, trickery, or fraud committed by law enforcement officers or agents to induce a defendant to commit a crime. And the second element is the origin of the criminal design in the mind of the government officials rather than that of the innocent defendant, such that the crime is a product of the creative activity of the law enforcement officer. So, for example, a policeman goes to the house of X, knowing that X had just completed his rehabilitation program for drug addiction. Then he tells X, do you know where I can buy shabu? X says, I don't know. I don't take that anymore. The police officer, pretending to be a private individual, says, oh please, I just really want to have a fix. I just need shabu. I was told that you are the person to ask. And X, to repeat, who had just finished his rehabilitation, refuses to tell this person where he can buy the best shabu in that village. But after a lot of persuasion, X finally accompanies this police officer to Y, who has a lot of shabu with him. Y is in fact very happy to see X, whom he hadn't seen in a long time. Right there and then, the police officer announces that that he is a police officer and he is now arresting X. The court would call this, or the court would have to acquit the accused because this is a clear case of entrapment, of instigation. In instigation, the mens rea or criminal design begins with the law enforcement officer. On the other hand, in entrapment, a person has already planned or is about to commit a crime, and ways and means are simply resorted to by the police officer to trap and catch the criminal. Entrapment, therefore, will not be a bar to the prosecution and conviction of the lawbreaker. Now, you're going to say, but isn't there a presumption of regularity in the performance of official duty? Why would we call the first case instigation? Wasn't the police officer just performing his duty? The court said that it is imperative that the presumption of regularity in the performance of official duties by law enforcement agents be applied with studied restraint. This presumption should not by itself prevail over the presumption of innocence and the constitutionally protected rights of an individual. It is the duty of the courts to preserve the purity of their own temple from the prostitution of the criminal law through law enforcement. Courts should not allow themselves to be used as an instrument of abuse and injustice, lest an innocent person be made to suffer the unusually severe penalties for drug offenses. Now, suppose that the instigator is a private individual, then he will be liable as a principal by inducement. Know, however, that there is no instigation if the crime is accidentally discovered by the policeman. If X, who had just been released from rehabilitation, is walking towards the house of Y, and they are now talking, and Y is handing over a packet of marijuana to X, and this is actually discovered by a policeman in plain clothes, who arrests both X and Y. This is not a case of instigation because the crime was accidentally discovered by the police. In entrapment, this is neither a mitigating circumstance for the accused nor an exempting circumstance for him. The offender is suspected of selling medicine at a higher price than that fixed by law. The policeman pretended to be a buyer and paid the offender with marked money. This is a form of entrapment, and it will not excuse the seller of the high-priced medicine. The difference between instigation and entrapment is that it lies in the origin of the criminal intent. In entrapment, the mens rea originates from the mind of the criminal. In instigation, the law enforcement officer conceives the crime, suggests it to the accused, who now adopts the idea and carries it into execution. This is the end of Article 12 on exempting circumstances.